What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Hey, money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
Everything that guy just said is bullshit. Thank you.
Hey, everybody, it's me and Megan. It's me, Legal Vices, and Megan Fox, not that one.
Nope, the other one. The one without the toe thumbs and the blood sucking.
And even though you're medium smart, how does it feel to be the smartest Megan Fox around?
Pretty good. Pretty good. Not bad.
Oh, we don't even have a like and subscribe poll set up on my stream here today. It's just one of those days. Just be lucky you got me at all. No poll today. Just hit the like and subscribe. Your choices are yes, okay, and of course, mother effer. Those are your choices.
I like that. And I am also having a lazy day. I really phoned it in for the bingo card today. It's literally the easiest bingo on earth. And if you motherfuckers don't get bingo in the first 5 minutes, there's something wrong with you. I'm sharing it if you want to bring it up on the screen so we can go over it.
And can you?
Is my mic too loud?
No, not to me. Did you send me the link?
I did on Twitter, on your DMs and Twitter.
Open up Twitter while you're reading through it.
Okay. Dog pants. Dog barks. Big words. Yoda side eye. Flux sighting. Cigar. Latin. Hair talk. Jeff sigh. Unreasonable demands. Mom shaming. Blam, blam, blam. Muppet voice.
Wow.
Inappropriate dog toy. Dog snore. I've covered all the options now.
Nice. Why are they all focused on me?
Timestamp. Legal Vices cowboy hat. We can check that off right now.
Dang it. I was thinking about putting a baseball cap on, but it didn't go with my shirt, so I put the cowboy hat on.
I took a risk and I got it right. Grifting, bourbon, passive-aggressive pause, recitation of the record, Megan yawns, not Steve Gosney, and YouTube is asshole.
Well, unfortunately, due to certain things, namely my boss telling me at 9 p.m. tonight that I have to work at 8 a.m. on a Saturday morning, there will be no bourbon.
Oh, see, I took a risk though. Usually there was, but there is.
There ordinarily would be, and I need it now more than ever.
But wait, I have some.
Oh, there you go. I just assumed it's all about me.
If it gets bad enough, I may have to pull that out.
Yeah, and no cigars either, because all the nicotine in cigars keeps me awake, and I need to sleep so I can drive and do the worky stuff tomorrow. Ugh.
Yeah.
Anyway,
bingo today because I was lazy, and
I've
it's
got the
Friday, and I'm tired.
And we're
I'm yawning already.
Oh dear. Oh my. Yeah.
Megan yawns. We now have 3. We're already. I'm already on my way to a bingo.
I haven't even. All right, let me open up the link here. What do I need to check off on the oldie Gosney Griffith bingo card?
Let's see. Megan yawns and Legal Vices cowboy hat. We've got those 2. And if we had started when we first got on the screen together, we could have gone dog bark because I heard that. And Jeff screams in Muppet voice.
All right, I'm missing one. Legal Vices cowboy hat. All right. There we go. Darken the screen. Turn it to dark mode. Glare be gone. There we go. Glare be back. Glare be gone again.
I was like, wait, your glasses tell a different story.
Yeah. It went away then again. Well, we are in part 8 of the Judge Grudge is Back, the Neighbor Wars, part 8. And this will be the last chapter for now. And it's not over by any stretch of the imagination, but we need to mix it up a little bit. We've been doing this for, well, not counting my suspension, 8 days in a row. Counting my suspension, 2 weeks.
Yeah.
So that's where we are. We're gonna put this aside. We're gonna get up to modern times now, and then a little bit later we can look at what's happening in the other case, the civil case involving the Gosneys and the Griffiths, as well as lots and lots. Hey, we can go with this forever because we've got 916 pages of transcripts and stuff we can read if we need to. So we can pick this up at any time.
At any time, yes. Which is fun because we'll wait for the next lull, because there's a lot of crap happening right now. So we have to take a break after this and get back to regular programming. But we'll be able to pick it up whenever there's a lull, which would be great.
And I'm in the process of setting up Doggo Cam because I promised Doggo Cam to people.
That's right.
Yesterday.
We get Doggo Cam right away, which is why there's a lot of Doggo stuff on the bingo card because I knew that was coming.
Why is extra camera not registering? There it goes. All right. Move everything. Mother, father. That was some good vodka that just spilled on. Now don't drink it, dogs.
Oh no. I did not have really drunk dogs on the bingo card. How did I not have dogs getting drunk? Dogs drinking bourbon or vodka?
This is delicious vodka.
Flux sighting. We can check off Flux sighting. Flux,
you made the bingo card.
Flux, you're on the bingo card today. I phoned it in. I made it easy.
I'll have to put the tripod over the top of the vodka to try to do a good job of preventing the dogs from drinking the vodka off the floor.
Oh, what? Flux goes, wait, what? Flux, you're gonna have to go to the bingo card to understand, but you're on it. Oh, there we go. Somebody's drinking the vodka.
Someone's sitting very, very close to the camera. Eye in the vodka on the floor.
Oh, but watch out for Yoda side eye. That is also on the bingo card.
Just breathe in the vapors.
Thomas wants to know legal advice. Says, why in the F do you have floor vodka?
Well, it was desk vodka, and then I thought, okay, I don't want to spill it, so I'll put it on the floor. And it has a glass stopper, and then it fell over, and the glass stopper popped out, thus relieving me of a decent amount of vodka.
Oh no!
But the room smells great. It goes in for the kill.
Yoda, it's like I know there's some of it down here somewhere.
Meanwhile, Strawberry's missing something. All right, that's
inappropriate dog toy. There it is.
But isn't it an inappropriate dog toy before she picks it up? Or is it her actions that make it?
I don't know. It's just I just had inappropriate dog toy on there, and I can see it, so I feel like it's on camera. We should be able to check it off.
Okay. Whatever. Sarah Adams says, Megan, I want to see other people. I don't know what that means.
She's mad because we're streaming so early. She's on the West Coast.
Well. That's okay.
She's like, it's 6 a.m.
Well, it'll wake you up, maybe. All right. Wayne S. starting out here. It's all about Megan this morning, people.
It is? Oh,
yes.
Another song in your mail, says Wayne. Okay, I'll check. Thanks for the 2.
Well, don't go yet. We've got more of that
Unhung Hero, thanks for the 2. The dog's BAC. What's a back? Dog's back is over the roof.
Blood alcohol content.
Blood alcohol. Look at Yoda. He looks like he's about to pass out. Aw, Yoda.
That's the most lame-ass bone licking I've seen.
Put your back into it, Yoda. My God, what is this? It's just like
we're all just out of energy today.
Yes,
Like,
we're all
like,
dragging.
I'm gonna chew on the bone.
Maybe not.
Nah.
Mary Thurston, thanks for the 5. I watched you and Tug 3 times, 2 and up 1.5 speed just for the laughs. Last night's show was hilarious. We went over the first part of Lynette Preston's deposition.
Yeah, I'll probably be doing that on Monday.
Oh, it's so good. And part 2 is going to drop tonight on Jeremy's channel around 5:30. So I'll be there for that.
Well, well, and we have Megan Fox's. I'm hosting this little shit show this evening, so Megan Fox is here, but she's also live on her channel. So, well, apparently y'all know that because all the super chats are all about Megan. They're all about Megan. So you apparently all know that she's live and doing her thing. If you
somebody send Jeff some super chats,
No.
please.
They're just out for the dog. They got the dog. They don't need to do anything.
They're here for the dogs. You already
Absolutely.
gave in.
Yeah, I don't give a shit about me. No. If you're over here and you aren't subscribed to Megan Fox, even if you are, just go over there and like the video. Come back, but like the video, like the video and subscribe to her. And if you are on her channel and you're not subscribed to me, please do. And also please hit the like button for me. Let's share the likes and share the subscriptions. That's what it's all about. Thomas, wait, where'd it go? Oh, did it scroll up too far? Dang it. Or is that I can't find it. Where'd you go, Thomas?
Just like that, Jeff is beating me in the super chat wars. There you go.
I can't find. Why isn't this showing up?
What?
This message. Oh, I see, because I forgot. There we go. I forgot there's lots more than just my stuff here. I'm like, but it's right there. Why isn't it showing up? It's just all Megan stuff. Thomas says, legal advice, the vodka fell down.
My child just fell down.
Jeff, have you watched it? The
no.
First,
no,
God,
I'm gonna watch it. I'm gonna watch it live.
And here's the most amazing part. Jeremy tells me, he's like, well, the first part starts out slow, but after that it gets crazy. Last night was insane.
Okay.
So, I'm like, that was slow? You think that started out slow?
Jill M says, love you, Jeff. Oh, thank you very much, Jill. And we have T's spreading the love.
Yeah. Oh, wow.
Always.
Wow. Yeah, wow. Jeff's beating the crap out of me on YouTube super chats now.
T is T sending her love down the well. Foghorn.
Nice.
Early morning grifty bucks. Thanks for the doggos. Oh, got to adjust it because Yoda twitched. Yoda just fell over. Yoda fell down. Thank you so much.
Flux says today's bingo card is fire. I'm like, yeah, it's the worst bingo card I've ever written ever. It's the easiest bingo to ever get. I'm tired. It's Friday. Give me a break.
Yeah. K Mountain Red Queen, thank you so much for the $5. Morning or evening wake up call. That's us. I think we
can check off grifting. We can check off grifting.
Oh, was that on there as well? Geez, you did put everything on there, didn't you?
I did.
I almost feel compelled to smoke a cigar.
Oh,
well,
man.
I'll tell you what. Just for giggles, we'll do a tiny bit of bourbon.
Okay,
perfect. Why not? I have been drinking Korean rice wine,
bourbon,
makgeolli, at an office party. So, and I do have to wake up early, so can't do much of it. But just to tick off the box.
You know, I may add a splash to my coffee as well. You know, as long as we're doing it.
Hey, the kids are in school.
Kids are in school. Little apple.
Mommy
bourbon,
needs her medicine.
Little apple bourbon in the coffee won't hurt anybody.
Yeah. Mommy needs her medicine. Rare in the history member for 23 months. Jeff coming in clutch for us. Hashtag Megapint. Let me all know if somebody gets down to just needing cigar for a bingo. I can hook you up. And it might be me if Yoda starts snoring.
I think I like this bingo card. making Jeff do all the things just to win bingo.
Yeah. Sleep.
Sleep. Oh.
All right. Again, that's our 17 minutes of bullshit. It's time to get down to business.
Look at how it is. Almost exactly 17 minutes.
Yeah.
Amazing. We're amazing at this.
Ike says, all I need is a cigar.
I like how Jeff starts out. I will not be drinking anything. I will not be smoking cigars. Well,
I think I just sighed too.
Jeff sighed. Oh God. Oh man, Tease T sitting with the huge 50 says I need some mom shaming. Well, never say that I don't give the chat what the chat wants. What should I shame you about today? What are you doing wrong today?
Well, hang on. Just keep shaming for a minute or two. I'll be back.
Okay. What do you need shaming for though? You need to give me a topic. Just oh God, the chat really likes the easy bingo. I had no idea you would like this so much. Oh God. The spilling of the alcohol. Yes, maybe I should mom shame Jeff. For God's sake, Jeff, can't you get an alcohol cart like everybody else? Why the hell would you put that on the floor? Can't you get an alcohol cabinet, locked behind doors the way adults do?
Who, me?
Yeah, I'm mom shaming you for putting your alcohol on the floor. That was the chat suggestion.
It's because I have a whiskey room. I'm sorry. I have a room. It's down at the end of the hall where it's my cigar and whiskey.
For God's
room.
sake, why can't you get a trolley, like a drink trolley, and put it on there? What the hell are you doing? Like a normal person with a drinking habit, you put it on a trolley and you roll it around the house.
Oh, is that what you do? All right.
I guess
Forgot
we used to call that the
Hang on.
Canarble wagon. Oh God. He has an entire room. I want a whiskey room. That sounds like a good idea. All right. You may check off mom shaming.
You used to call it the what?
The Canarble wagon.
Why? Why would you call it something weird like that?
It comes from a radio show that I used to listen to in Chicago, actually, the Rokon and Gary Meyer show. They would roll out on Fridays what they called the Canarble wagon. And I actually don't know why it was called that, but it's the drink cart. And
all right.
Make drinks at 5:00
a.m. Drive time, morning drive time.
No,
drinks?
it was p.m.
Okay.
God, I loved that show. It was a great show. The newsman Jim Johnson would
oh my God, I can't. I'm trying to make you people happy. Just hang on again.
Is he getting his cigars? He's getting a cigar, isn't he? He's getting a cigar. I should have put pipe on there too, because then he could have chosen which one. I should have just said smoking. Smoking would have worked. We're now at 20 minutes of bullshit, Jeff. Don't roll over Yoda's face. Oh right, my God. Don't, you almost rolled into Yoda's face.
What's up, Yoda's face?
Don't. Oh
all
my
right.
Lord.
Now I think I've got everything to make you people happy. Jeez, you're so demanding. K-Matt and Red Queen. Oh, we already got that one. We got some mom shaming. All right.
We got that.
We're actually not going to do a show. We're just going to read super chats all day. Debbie Marie with the $5. Just cuz, Jeff. Looking forward to the laughs today. Maybe there'll be some, maybe there won't.
The chat says unreasonable demands should be checked off because we're making unreasonable demands of you.
Oh, that's in there too. I'm sure. Work it off. Totally in agreement with that.
I still don't have bingo. I can't believe it. I can't believe I don't have it yet. I need YouTube as asshole, and which really should just be a free space.
It should. Well, why did you put the bottle on the floor? Clearly should have chugged it instead, because there's way too much to be chugging. That's the problem. And Jack's mom with the $2. I need a passive aggressive pause, please.
I'm sure we'll get there when we're reading.
Yeah, it just happens. All right. Well, our 17 minutes of bullshit has turned into 22 minutes of bullshit, just because of you people. So people in the replay, don't blame me. Don't leave hate mail about how we just shut up and get on with it. Blame chat. Meanwhile, mark off cigar. All right.
Awesome.
Now snore, bitch.
or bark, or pant.
Or just do anything. Just make noise. Squeak. All right. Lone Star Living, I'll have double bingo with some hair talk.
Oh God. Whoever needs yawn, I already yawned. You can check that off. That already happened.
Yeah. All right. We do have things to talk about. I was just kind of semi-facetious. We do actually have things to talk about. And one of the things we got to talk about is, as you know, we've been covering lots and lots and lots of stuff. And the lots and lots of stuff we've been covering are the hearing involving the Gosney family and the Griffith family as they battle each other in court over the protective orders. The Griffiths want it taken away. The Gosneys want it left in place. There's a big kerfuffle. Judge Grudge goes off the rails, starts accusing people of recording the session, and he goes on to talk. He's not gonna let him have Jew night off. He's gonna make him go right till sundown, conflicting with the Jewish Sabbath. He can't go. There's no way. It's impossible to go past 5 p.m. But he goes till like nearly 7:55 p.m. Which he's checked with NASA and or the Farmer's Almanac to determine that's.
Oh, I got a clarification on that. The Farmer's Almanac was just a typo. It was NASA.
I get those two confused all the time too.
It was just a lapse in memory.
Yeah. And then he started accusing both the Gosneys and Randall Shockett of lying and fabricating and setting up traps to force violations of protective orders. In the middle of the hearing, they stopped and said, we got to file this. We got to file a motion to have you withdraw from the case. They did. He denied it. They filed a written, they filed a second motion, which we read yesterday, denied that. And then they filed a petition for a writ of prohibition. That's filed with the Supreme Court, with the Florida First District Court of Appeal. Now, we've seen this before in the Hales case, also involving Judge Grudge and attorney Randall Shockett. Mm-hmm. They filed the petition for writ of prohibition against him. It went up there and they threw him off the Jeremy Hales case. And that's what they've done in this case. And by them, I mean the Gosneys and Randall Shockett. They have filed another petition for writ of prohibition to get him booted, to get Judge Grudge booted off the protective order case, as well as a civil case involving the Gosneys and Griffiths. And this is a 58-page motion, and this is not a wasted word motion. This isn't like 5 pages plus a bunch of attachments. This is 58 pages of explanation as to why Judge Grudge should be thrown off the case. And essentially what it is, it's an amalgamation, it's a consolidation of everything they've argued in the initial motion to have him withdraw, to have him recused, the second motion, and everything in between. They're just restating everything, what he did in court, what he did during, what he said in his order, and all these other things. They've just put it all together in one single document for the Court of Appeals to review and decide whether or not to throw Judge
Look where
Grudge.
you are, by the way. Stop right there. Stop. Go back up just a little bit to the top of this page. Just this one sentence. No, you went too far. Go back down and go back down a little bit. Top of the next page, top of page 11. There it is. If I'm on the appeals court, I only need to get to this part right here. It was filed later that day, as noted by Judge DeThomasis at 3:59 and 22 seconds p.m. And I'm like, who is this dick? Like, get this guy off the bed.
I think we can mark off timestamp now.
Oh, yeah. Timestamp. I didn't even do that on purpose.
Oh, yeah. Sorry, I was like moving my foot around. I'm like, God, what is on the floor? Why is it? Oh, vodka.
It's going to evaporate before you get to a towel. It'll be fine.
Then my floor will just be sticky and smell like cherries. Okay. Well, see, I don't want to redo it because this is everything we've been talking about literally for the last 8 days.
Yeah.
Is in this one motion. So just kind of scroll through the April 18th order.
Right. So we know that this is the same,
what he
all
wants.
those reasons that we went over the last couple of days, why he needs to be thrown off this case.
Yeah. The arguments and all the accusations that have been filed against them.
Oh, there's the sunglasses.
Yeah.
Are you recording me? Do you have a recorder
Mr.
on?
Gosney? Do you have a recorder on?
No, sir.
Okay, what is that?
My phone.
Piece of equipment. I'm sorry. The lighted.
No, that's mine.
The lighted object there.
This?
Yes.
Sunglasses.
Oh, all right. No. So from here, like, reflecting off is reflecting. It's glasses and
No, sorry.
Yeah. That's just one among many, and this goes on, like I said, for 58 pages. And at the very, very end, of course, is the wherefore the petitioners William and Brenda Gosney respectfully request that a writ of prohibition be entered, removing Judge Craig DeThomasis from further participation in their pending cases in Levy County Circuit Court, to wit, this case and that case. But
Excellent.
what I want to start out today, reading the full motions. Go away percentage? There we go. This is a motion for order to show cause. Now, this is because this protective order is separate from a civil case they're involved in. And this is basically an order asking DeThomasis to suspend everything that's going on in the other case while they decide whether or not he's going to be involved with that case any further. So I will start, and then Megan will start with paragraph 1. I have to read the magical lawyer words.
Wonderful.
Pursuant to Rule 9.100H and 9.300 Florida R. App P, the petitioner William Gosney and Brenda Gosney request an order to show cause directing the respondents, and as good cause therefore state as follows. Ding, 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 ding. Incense. Okay, go ahead.
Petitioners and respondents are parties in 2 cases pending before Judge Craig DeThomasis in Levy County Circuit Court.
So that's important to note. 2 cases, this one and the civil case. Well, anyway, a petition for writ of prohibition has been newly filed to prohibit Judge DeThomasis from further participation in these cases in accordance with Section 38.10 Flaw Stat and Rule 2.330 Flaw Gen Prac and Proc. That's the Florida Rules of General Practice and Procedure, in case you really want to know what this is.
Although no further activity on the trial court level is expected to occur in the injunction case, while an appeal ensues, the civil case is very active, and there are discovery motions as well as motions challenging the pleadings that need to be addressed by a court.
Good cause exists for this court to issue an order to show cause to pause proceedings in the trial court while this court considers the merits of the petition. So they're asking the I don't remember where we are. The
appellate
district court appeal, the District Court of Appeal of Florida First District. They're asking them to suspend the proceedings in the civil case as well.
What number are we on?
5.
The petition for writ of prohibition sets forth several legally sufficient bases for a writ of prohibition to issue, along with supporting facts and transcript references. These bases include Judge DeThomas's excessive participation and independent fact-gathering at hearing in the injunction case on April 12th, 2024, creation of an adversarial atmosphere that permeates the case, extreme antipathy and retaliatory conduct towards petitioner's counsel, Randall Shockett as Esquire, whom respondents joined as a party in the civil suit, negative prejudgment of petitioner's credibility, and prejudgment of certain substantive claims in the civil suit, one of which also includes petitioner's attorney. And I got to say, there were a lot of big words in this paragraph. I think that we can check off big words. I was just going to
ask, does antipathy count as a big word?
Yes.
Okay.
And look, there's adversarial, antipathy. There's just a bunch of them. Permeates, retaliatory.
Flug says she feels special. She's in the bingo card.
I figured she'd like that.
Petitioners have already been prejudiced as a result of the bias exhibited by Judge DeThomasis, which is expected to continue and become more extreme with his continued participation. Wherefore, Meg?
Wherefore the petitioners, William and Brenda Gosney, not that Steve Gosney, respectfully request issuance of an order to show cause in the above caption matters in the lower tribunal.
Shameless.
We're just cheating
Shameless.
today.
Mark off not Steve Gosney on the card.
It's Friday.
It is.
I still don't have bingo. I need
Nor
dog
do I.
snore.
Me too.
I need dog snore.
Oh, you did mom shaming. I have bingo.
Oh yeah, I did.
Yeah. I wasn't here for it, but you did it.
Well, now you have to generate a new card.
Yeah. I'm going to go for blackout.
Oh, okay.
I'm going straight for the blackout. All right. So that is the end of this motion. So what happened, you ask? Well, they apparently didn't need to rule on this particular motion for reasons. One reason, here we go. I am bigging that way too much. There we go. The First District Court of Appeal for the state of Florida, in this case of the Gosneys versus the Griffiths, on the writ of prohibition, the 58-page motion to get rid of Judge DeThomasis on this case and the civil case, they issued their order. They issued their decision. Megan, do you have the button ready?
I do.
I do. And it says down here on the bottom, it was issued on August 13th per curiam. What per curiam means is all of the judges that heard this case on this Court of Appeals,
three panel,
100% of them, every single one of them agreed with the judgment. And the decision on whether or not to remove what's his face, Judge DeThomasis is dismissed.
Denied. Sit down.
That's it. One word. Dismissed.
We've read the other order, the one that came from the same court, different three panel of judges though, about the Jeremy Hales case, and it was like a solid page and a half, right? 2 paragraphs at least, with an explanation of why. And if you ask me, this makes no sense. No sense. Oh yeah, Latin.
Per curiam, yes.
Oh my God, I love this bingo card so much. I love it so much. It's so easy. This, if you ask me, I think that the Gosney case, I think he behaved even worse than the Jeremy Hales case. So you have to really ask yourself, the hell is going on with these appellate court justices that they are not seeing it?
Well, and that's the one thing I've been saying since day one. I said, you thought the Hales case was bad. This is worse. This is just worse. Because this is being done while the other case is going on. He's mad about the Hales case and he's taking it out in this case and he's making it worse. The Court of Appeals,
they read that. Nope. It's hard to believe that they read those 58 pages and came to that conclusion. So my thought is, was everybody bored and busy or not paying attention that day? You did get it. It is a different 3 panel of judges. It's so you get 3 judges and sometimes it's 3 different, it can be anybody that's on the appellate court. So you just never know who you're going to get and what their decision's going to be. But it really makes no sense. How could he be tossed off of Jeremy Hales's case and not be tossed off of these 2 cases where he behaves so much worse?
Yeah, I say where this to me is worse on multiple levels.
Yeah, the inconsistency is really unbelievable. But there is still an avenue. So there's more filed
So,
in the
so
case.
for right now, as we stand, Judge DeThomasis is still on this case.
Mhm.
Well, well, I mean, I guess this case. Well, this case still kind of does exist. The protective order was removed, but we're still trying to get him off the off the bench in the other case.
Mm-hmm.
There you go. There's a free dog.
Oh, dog pant. Perfect. I don't have double bingo though.
I don't have.
Weird.
Oh, I do. I have the mom shaming that give it to me. Anywho,
Wait, I didn't get bingo yet today. I still don't have bingo. This is so weird.
Yeah,
I have so many. My card is almost full, but I have no bingo.
That's how I was yesterday. I'm like, how did I not? I had 5 spaces open. How was it possible I didn't have bingo?
Right now, I could use dog snore, YouTube is asshole, and passive aggressive pause to give me any bingo in any direction there. But it's just very strange. I'm not getting.
I'm sure we'll get you there. No worries. I'm sure we'll get you there. So what happens from here on out with Judge DeThomasis, you might ask? Are they just going to take this laying down or lying down? The answer to that is no. No, they are not.
No.
What?
I'm just laughing at your no.
Because the Gosneys as petitioners have filed a motion for rehearing, consolidation, and for en banc review.
Oh, more Latin.
More Latin. Now, what an en banc review is a review by the entire Court of Appeals. All of the judges on the they want.
Oh,
all
now
of the
that will be interesting. I didn't know that's what en banc meant. That will be interesting because if all of the judges, that means the 3 judges that kicked him off the other case will be rehearing it. Do they have to accept this? Do they have to hear it when you file this, Jeff, or is this something they get to choose? Do you know?
I don't know. I don't know. But en banc sessions, I mean, they're normally for very serious matters. So I know for like the Supreme Court, they can decide whether or not to hear it.
Right.
And this is a question of law. So I would assume.
This is going to be very interesting. I can't wait to read this. I haven't read this yet.
And this was filed on 8/28, so August 28th.
Oh, just recently. Oh my goodness. Yes. It's only September 6th.
It's a week ago.
Ooh. I'm cited. As my little one when he was 2 would say, "I'm so cited." I cited.
All right.
Yesterday, my daughter was tired. My 15-year-old was tired, and we were at some appointment, and she was talking about school, and she goes, "Yeah, and my pack back it's too heavy." And I was like, "Did you just say pack back? You haven't said that since you were 6."
Aww.
Oh, it's so cute. My pack back, it's just too big.
You should make fun of my sister for saying elephant fulminant.
Oh, and for those of you who know my sister, by the way, Stephanie, she's coming to see me today. She decided she's driving up.
Wow.
So I may be able to do a stream with her later.
Wow. How long is she staying?
If I can fit her in here. I might be able to fit her in here. How long is she staying? For the weekend.
Oh, hey, if Sarah Boone can fit her boyfriend in a suitcase, you can fit your sister in the room. Just saying.
Oh my God. That tweet you put out yesterday, no. I was dying. That was horrible. That was so bad. Of that woman falling down the stairs in the suitcase. Who thinks that's a good idea? Like, here, get in the suitcase and I'll push you down the stairs. Oh.
Well, the first time it caught and then it flipped and her face hit the stair, I just thought, ouch.
I thought it was going to be like a bloody mess. Yeah. Oh, horrible.
But speaking of bloody messes, more stuff from Megan.
Truana shutta bada pressure bada fuck care. Thanks for the 2. You are a professional. I know, I'm trying.
And Megan has just become a Pentecostal. She's speaking.
I was raised a Pentecostal.
Yeah, I know. You reverted your natural ways. You started speaking in tongues again. And BK for Megan Fox.
And apparently, by the way, Doreen Inglis, who wrote all of these motions that we're reading, she just wrote an article about writs that was published in the Florida Bar Journal.
Yes, she did.
That came out. We actually have I have a link to that. And it's called Decision or No Decision, Getting Carded at the Successive Writ Bar. I like that headline. That's a good headline. So that's interesting. I'll have to send you the link to that.
Yeah, I have it as well.
Oh, you do? Okay.
Yeah, she sent it to both of us. BK wants you to read her super chat.
Oh, BK, thanks for the 10 to make up for yesterday. Jeff, y'all cracked me up.
Wait, you sent that to Megan to make up?
That's for you.
No, that's yours.
I don't see the link on it.
I do.
Oh. Well, I'll make sure Jeff gets it. Don't worry.
Yeah. And Lone Star Living, that's for me. I'll have double bingo with some hair talk. We'll get you there. We'll get you there. Hang tight.
Double bingo with hair talk. Oh, okay.
I'm sure we'll get you there.
I don't have anything to tell you about it yet.
Yeah.
But maybe I'll come up with something in a minute.
All right. CMB, did you miss much? No. No, you haven't. We've only been going 42 minutes. How much could you really have missed? Okay. Well, so this is what they've done. They want the entire Court of Appeals, not just the 3 judges that heard that read the previous writ. They want the entire appellate court to read it and hear and reach a decision. So here is the motion for that. And I've read a bit of it, and it seems pretty interesting. I like the way it's worded. I like the way it's phrased. I like the way it's put together.
Doreen's a very good writer. Very good. I also enjoy her writing.
I concur.
Are you starting?
Okay. This is far too long for me to read all of the legal magic words in one voice, in one breath. Petitioners William Gosney and Brenda Gosney, by and through undersigned counsel and pursuant to the rules, this and that of the Florida Rules of Appellate Procedure, file their consolidated motion for rehearing, consolidation, and for on-bank review of this court's August 13th, 2024 dismissal of petitioners' petition for writ of prohibition seeking to prohibit Judge Craig DeThomasis from continuing to preside over their present ongoing civil lawsuit. In support thereof, petitioners state as follows.
Makes me laugh every time. General overview. This petition for writ of prohibition is complex, as it involves 2 related cases presided over by the same judge, whose improper conduct and improper comments during one case necessarily require his disqualification from both cases.
And I agree. The posture of the 2 cases is different. The case in which 2 motions to disqualify Judge DeThomasis for bias were filed requires no further judicial labor by the trial court, although the final order is on direct appeal. So they're just saying that we don't really have anything else to do in the protective order case, but we're appealing it. But we still want him off of it.
The other case involving these same parties, same attorneys, same judge, and related facts is ongoing and requires extensive judicial labor. That judicial labor, however, cannot and should not be performed by Judge Craig DeThomasis because the clear and overwhelming prejudice, hostility, and lack of neutrality he demonstrated toward the Gosneys and their attorney, Randall Shockett, in the case now under direct appeal.
See, and I like how that's worded. It's just there's a lot of judicial work still to be done, but not by him. By anybody else, just not him.
Chat, cigars already checked off. Jeff's got a cigar.
Yeah.
So if you are waiting for cigar for the bingo, you got it.
Yeah.
Wait, is it my turn or your turn? No, it's your turn.
Yes. These complexities may have contributed to the panel misapprehending. You don't tell the judges, you don't say that the panel of your peers made a mistake or are dumb or stupid. You tell them they've misapprehended why it's necessary to grant this.
Misapprehended. Okay. It's funny.
These complexities may have contributed to the panel misapprehending that a writ of prohibition is necessary to forestall a present impending injury in the Gosney ongoing civil case, which will not be remedied through the pending appeal in the other case. So essentially what he's implying that although the other case has been temporarily resolved but is being appealed, he believes that they may not have realized that it also is requesting them to remove Judge DeThomas's from another civil case involving the same parties. They may have misunderstood that there's an ongoing civil case.
I like this headline. The tale of two cases.
Don't you?
A tale of two cases.
That's what I'm saying. I love it. This is as far as I've read. I've only read to the end of the tale of two cases.
Specifically, the Gosney's petition for writ of prohibition filed June 4th, 2024, encompasses two circuit court cases involving the same parties, next-door neighbors, the same attorneys presently, and the same judge, Craig DeThomasis. The face of the petition reflects two circuit court case numbers, 2019 DR 539 and whatever. The Gosneys timely filed their motions to disqualify Judge DeThomasis in both cases. Simultaneously, even though the judge's conduct giving rise to the two motions occurred in case number whatever, the judge's orders denying both disqualification motions were also filed in both cases. The Gosneys filed their petition for writ of prohibition in this court 12 days after the judge denied their second disqualification motion.
Oh, wow. That was probably perfectly sent a text message during that paragraph. Cool. Just finished right as soon as you said that. One of the cases, LT number this one, involves an injunction prohibiting repeat violence that the Gosneys obtained against Philip Griffith in September of 2019. 4 years later, in March 2024, Griffith reopened the injunction case by filing a motion to dissolve. That hearing occurred on April 12th, 2024, and the ruling was rendered April 18th, 2024. The Gosney's first motion to disqualify the judge for bias was raised orally and then filed mid-hearing on April 12th, 2024. The judge denied that motion the same day, and the rest of the April 12th hearing resumed into the evening.
Oh my God.
The duration of that hearing itself became a basis for disqualification, as discussed in the petition for writ of prohibition.
The Gosney's second motion to disqualify the judge for bias was filed on May 2, 2024, which was still within the 20-day period prescribed by Rule 2.330G. To address and readdress, I like that, to address and readdress Judge DeThomas's improper conduct and comments at the April 12th hearing, as well as within the time period to address the other basis for disqualification arising from the April 18th order. And we have a footnote.
A long one.
It should be noted that the Gosneys had to file a motion for rehearing of the April 18th order for the purposes of preserving certain issues for their appeal. Although they filed that motion with the clerk of the court, they did not send it to Judge DeThomas's for a ruling because their second motion to disqualify was pending before him. The judge denied the second motion
Sit down.
to disqualify on May 23rd and issued his order denying rehearing on June 4th.
Sit down.
Just a few hours before the Gosney's petition for writ of prohibition was filed in this court. With the rehearing motion resolved, the Gosneys filed their notice of appeal of the April 18th order a week later on June 11th.
The other case, LT number 202-2023, CA58, is a civil lawsuit filed by the Gosneys against the Griffiths for intentional infliction of emotional distress, trespass, and nuisance. The Griffiths later filed counterclaim against the Gosneys and a third-party complaint against the Gosneys' lawyer, Randall Shockett, Esquire, for abuse of process.
Not only are the parties, the attorneys, and the judge the same in both cases, and we have a footnote again. Should we skip there, or you want me to finish the sentence?
Kimberly Griffith
Is not a party to the injunction case. Okay.
Scuttle, scurry,
So not only are the parties, the attorneys, and the judge the same in both cases, but there are also overlapping facts which implicate prejudgment of claims and or adjudication of issues not before the court. Specifically, Philip Griffith's continuing aggressive, threatening conduct towards the Gosneys after the entry of the 2019 injunction formed the basis of their civil tort claims, and also why the Gosneys continue to fear Philip Griffith and want the injunction against him kept in place. Stated another way, the facts set forth in the Gosneys' tort claims for affirmative relief in the civil lawsuit are also their defenses to Griffith's motion to dissolve the injunction.
I don't think you can hear the dog snoring.
Oh.
Well, Uriah says, where are we here? Okay, I'm convinced the doggo isn't a lawyer, but I want him to represent me in my next case. Strawberry has left the building. We need to go back to this ball of energy here.
It's the vodka fumes.
Yeah. And also, Joy with the $2. Don't think the third panelist has a law degree. Thank you very much.
Either just the second panelist. Only one law degree is on this panel.
And I don't know how I got that. They gave it to me and they probably don't want to save me back for another semester. I don't know. In their misplaced zeal. I like that.
Zeal's a good word.
To get the injunction against Philip Griffith dissolved, his attorneys posited their theory that attorney Randall Shockett conspired with the Gosneys to stage a situation for Griffith to violate his injunction and or otherwise use the 2023 civil suit to somehow bolster the Gosneys' 2019 injunction case. Their theory also happens to comprise the gist of count 5 of Griffith's third-party civil complaint against attorney Randall Shockett for abuse of process.
I should have put tinfoil hat on the bingo card. That would have been perfect. My dog fell down, says Porcelain Thunder. Accordingly, Griffith's purported defense to having the injunction against him maintained indefinitely is the same as his claim for affirmative relief against Shockett in the civil case for abuse of process. In fact, at the April 12th hearing, Griffith's counsel not only argued their theory to impugn attorney Shockett's character and integrity, they asked Judge DeThomasis for specific findings on abuse of process. And even though abuse of process was not an issue before the court on April 12th, Judge DeThomasis gratuitously gave them those negative findings against Shockett in his April 18th order based on absolutely nothing. So this is like a setup.
Yeah.
It's like a setup. It's like you want to talk about the conspiracy. Is there a conspiracy between the judge and Kirchhoff to win this other case by finding these adverse rulings against Shockett when it wasn't even before the court in this one?
Could be. Rio, oh baby, for Megan Fox.
Elaine Bredehoff loves saying "Tale of Two Trails." Thank you, Rio, baby.
I don't remember saying "Tale of Two Trials."
Trials, Tale of Two Trials. I said trails.
Yeah.
Did she?
Trails.
I don't remember it either, but she might have.
I just remember, give it a whirl.
Muppet voice. Muppet.
No, that was a Mr. Rogers voice. That was the Lady Elaine Fairchild.
That was Lady Elaine. That's true.
Boy, if I'm out of practice, just that little bit scratched my throat. That made it. That was hard.
Can you imagine that you did entire transcripts like that?
Yeah, hours on end.
Sidebars were so fun. If you guys have not seen us do the Johnny Depp sidebars, Jeff does it, Elaine's voice, like that for hours. It's so good.
It was rough.
That give it a whirl moment. I think that's when I fell out of my chair.
Oh, I think it is. I think that's when you fell out of the chair and broke your Lego piece. Yeah.
I think so. And scene.
And scene. Yes. And Hayden was also involved in the reading.
Hayden was there with his Aussie/Southern accent.
Yeah. As he as the non-American on the panel, he was there for the accents.
It was so good. I think at one time he pulled out a Mexican accent. It was fantastic. Oh, go back and watch Johnny Depp sidebars if you're bored, guys. Let that playlist play.
I mean, not right now. I know they're bored
not
right now. Like,
not now.
Like when you're bored again later, not when you're bored right now.
Boring. This is boring.
I think I need to zoom out on Yoda a bit here.
He says, I regret nothing. Me either. It was a fantastic I was wearing a graduation robe, playing Judge Penny. It was fantastic.
All right. Well, we are moving on here.
Okay.
Just Don, you caught me. I like legal vices. I'm so ashamed now. Oh well, join the crowd. Let's go. I just sighed again. All right. The Gosney's second motion to disqualify had to be filed in both cases because in his order of April 18th, 2024, dissolving the repeat violence injunction, Judge DeThomas has not only prejudged Griffith's civil claim against Shockett for abusive process, which was not before the court, he adjudicated it. Judge DeThomas literally wrote in his April 18th order that the evidence is consistent with the Gosneys and attorney Shockett acting in concert to trap Griffith into a violation of the injunction.
Mm-hmm.
That language tracks directly and consistently with Griffith's allegations in this abusive process claim against Shockett, which is absolutely true.
Yeah,
that was what they talked about that in the first day of the hearing. When
he absolutely did.
That he's in on it, and they both tried to trap him into it, and that's the allegations, and he adjudicated it. Cannot argue with that.
This is what makes me think that 3-panel of the appellate judges just didn't even read it. They're just like, denied.
I think there may have been that misapprehension that they were talking about. They just didn't realize it was affecting both cases.
Oh, maybe.
They probably went, I think they looked at it and went, well, we already dismissed that case.
Right.
He already just vacated the protective order, and there's no reason to take him off of it now.
All right, those of you who are saying I should put up a called bingo boxes for the latecomers, forget it. Just start from scratch. It's so easy today that you will get all of them. It's so easy. You don't need to know what we've already checked off. It's happening all the time.
We're still going. You'll catch up.
I'm about to get bingo, and then I'm just going to redo I'm going to make a new one and start over. All right. We can do the reverse order though. If you're just joining and you don't have anything ticked off, you can tick off the ones you don't have and then untick them as we read them. Because right now there's only 1, 2, 3, 4, 5, 6, 7, 8. There's only 9 spaces that haven't been filled in out of 25. That's true.
And we just roll with it. If you think maybe we mentioned something at some point, just check
it off. Today is the easiest bingo ever.
Yeah, you
get legal vices. Get legal vices cowboy hat for sure.
You have a cigar. 16 out of 25 chance of getting it right.
And bourbon.
Yeah.
All right.
So you have whatever you choose, you have about a 66% chance of guessing correctly. So just go ahead, Megan.
Robert Tower says, I have 27 bingos. How then can the Gosneys or attorney Shockett, who is now a party to the civil suit, expect to receive a fair trial in the civil case on that count alone when Judge DeThomas has already determined the outcome in his April 18th order and found against them? As pointed out in the petition for writ of prohibition, Judge DeThomas has also made findings indicating that he prejudged or adjudicated other aspects of the Gosney civil claims, including for intentional infliction of emotional distress, which claims were not before the court on April 12th.
Shouldn't have mentioned those. Shouldn't have talked about them. K-Matt Red Queen with the $10. Thank you, Betty Munchie, as they say over here.
Betty Munchie.
I think they should have also suggested they watch video to watch facial disdain to Shockett and Klein. Oh yeah, they should please watch the hearing video so you can see how he acts. Throughout the transcription does not reflect or could have been corrected. The transcript will be correct. You're right. You can't get inflections or
tone.
Tone.
Or all the interrupting. Oh my God! Every time he interrupts Shockett, it doesn't let him talk. I love that part where he goes, "Well, we're past that now."
Yeah.
Like, Your Honor, I have another trial. I have pretrial stuff. I'm supposed to be in a phone call. Well, we're past that now.
Well, if they actually did read the transcript, again, it's the Bill Burr thing. Just what it says in the transcript doesn't sound like how you said it.
No.
You know, they're going to, oh, he just said, oh, is that a recording device you happen to have over there? Are you recording this? That's a little
I
different.
shot the clerk. I shot the clerk. Yeah. I shot the clerk. I shot the clerk.
You've heard the Bill Burr bit, haven't you?
I'm not sure.
He's talking about how, you know, you're with your girl. And she's like, no, stop. Oh, don't. Oh, you're so bad. No, stop. And then you get there and they're reading the transcript. No, stop. You're bad. No, stop. So you'd say it like you said it before. You didn't say it like that.
Yeah.
Yeah.
This is very true. And inflection is everything. I mean, in China, in Cantonese, the inflections change the entire meaning of the word. Do. You know, like you can be, and same in English though, because you can be saying one thing one way and it means something, and then you read it and it means something else. So I agree. I think that they should do reviews of the videos or at least the audio.
I concur. You win. I guess we're on 14.
Was that a passive aggressive pause?
Nope. That was, I can't argue with you. You got nothing to argue with you about. You're absolutely correct.
I'm just waiting for passive aggressive pause, Jeff.
Who knows? It's all of these paragraphs. Well, I'm the one that's scrolling, so there'd be no reason.
I know. I screwed that up.
But you can give passive aggressive pauses at any point you deem fit, and nothing I can do about it. But we are halfway through this, and we're only an hour into this, so we're reading too quickly. We're gonna run out of stuff.
Oh no, we're gonna run out of stuff and things to do.
Yeah, so we may just have to go into transcript mode for the remainder of the 2 hours.
Oh boy! Or we could watch the body cam footage from Laura Owens.
No, we don't want. Never cross the streams.
Don't cross the streams. I know. I knew you were
don't
going to
cross
say
the
that.
streams. But I did see a little bit of that. That was pretty funny too.
Oh, it's pretty funny. In fact, after this, I may go live on my channel and do it because I don't know when else I'm going to have time. So we'll see.
And as a means of wasting just a little bit more time, so we don't finish up too early. That's what she said. Just think of your grandma or something to make it last longer. We're at the halfway point. That's a good chance to say. Currently, I've got some people watching here. 342 of you are watching me, watching you. Watching me, watching you.
Oh, I didn't have Jeff sings.
Now I've got 411 people watching for some reason. Just a lot of people just joined. What you want to do is make sure you go down and you hit the like button on my channel. And take the like and subscribe poll. Please subscribe as well if you haven't subscribed. Please do. We're moving forward. We're inching our way towards 81,000. Yay. And we need all we can get, but there's no poll today. I always have a like and subscribe poll just to remind you to hit the like and subscribe. All we have is just hit the like and subscribe. 29% of you said yes. 15% of you said okay. And so far, 56% of you said, of course, motherfucker.
I forgot to put that on the bingo card. How did I forget MFer on the bingo card?
All right. And while you're at it, go on over to Megan Fox's channel. Subscribe to her, like her channel, and do all those YouTube-y things over there. And I would invite you to vice versa do that. If you happen to be over with her, come on over to me and subscribe and like, and then go back to her.
I've got 573 of you live right now. And
dang it, I was ahead of you for 45 minutes.
And only 321 likes. I've
got more likes. I've got 352 likes.
I'm going to have to do some mom shaming on that. You need to, your thumb's broken. I know your thumbs are working. And if your thumbs don't work, you could use an index finger. You could even use an elbow. Are you too lazy to hit the like button? Come on now, folks. Just go over to the little likey thing, the little thumb up, and you just push it. God, you kids are lazy these days. In my day, in order to like something, I had to walk about a mile uphill in the snow and write about it and send it in an envelope and put a stamp on it and stick it in a letter. You guys get everything handed to you these days, and you can't even click a like button.
Thank you for the super sticker, Luke Smith.
How was the mom shaming? You can, if you haven't checked that off, you can check it off again.
That was good. That was a good mom shame.
Hey, since we're running out of things to talk about, did you know that I was on Viva Frei yesterday?
Yes, you told me. You said you were going to study the Russian thing.
That went okay until I told people that I thought Trump made a mistake. Don't ever do that. Don't ever do that
Not
with the
on Beavis,
channels.
yeah.
With the channels that have the I don't recommend. The chat was so with me right until then, and then they turned. It got ugly.
They brought out the pitchforks and the torches.
Yeah, the pitchforks and the torches. But yeah, I talked about Larry's case about the thumbnail lawsuit. Here, I'll show you. This is a funny visual because I made him a visual aid because this case is so complicated. I made him some visual aids. Look at what I used.
Nice.
And so I went over the YouTube lawsuit, and Viva's when I told him about the first part of it, the part where Jeremy and George are being accused of doing a fake reality show and not paying this woman for making her a character in it, he goes, "That's creative." He goes, "I don't know how well it will work, but it's creative." It's a good way to do it. So yeah, I went over that with Viva. If you guys want, we read the lawsuit. We kind of talked about, fair use, etc. I think my hair looked really good, by the way.
Yeah, you talked about her hair.
There you go. I think my hair looked really good that day. So thank God. And then I had a computer shutdown. I had tech problems. I had a muted boomer moment. It was all good. You guys should go and watch this.
You just brought the full Megan Fox presentation to him there.
I did. It's the first time I've ever been on his show. I don't think I gained any of his audience though, because I think they hated me after I said some things.
Probably did. Well, we should get back to the case at hand, I think.
I was helping you waste some time. What do you?
Yes.
Is it my turn?
Are you done wasting time? There's a passive-aggressive
pause.
There you go.
Bingo.
Me too. I needed it too. That's why.
Was that passive-aggressive enough for you?
It was passive-aggressive enough for me, and that's all that
Damn
matters.
It. I think I lost my card before I could get a bingo. Oh, that's okay. I can just regenerate another one just because I know I won. All right, there we go.
Furthermore, the Gosney's second motion to disqualify had to be filed. Oh, you read that, didn't we? Did we?
I don't know.
It's been so long.
Had been filed.
No, I did not read the word assassinated.
No.
Furthermore,
I would have remembered that.
The Gosney's second motion to disqualify, which we read yesterday, had to be filed in both cases because we read half of it because in his April 18th order dissolving the repeat violence injunction against Griffith, Judge DeThomas improperly and gratuitously assassinated the character and ethics of the Gosney's attorney, Randall Shockett, denouncing Mr. Gosney as a liar and imputed nefarious motives to them both in bringing the civil action against Griffith. Oh, you could read bold stuff.
I'm calling gratuitously big words, and I'm checking that off. Okay. I also need to check off Jeff's cowboy hat. There we go. Even though the injunction case requires no more judicial labor at this time, how can the Gosneys expect to receive a fair trial in their ongoing civil case before the same judge who penned an order stating he does not believe they are truthful, does not believe their lawyer is truthful, does not trust the motives of either of them, and who in no uncertain terms stated he believes they conspired together to trap Griffith into an injunction violation that would result in his incarceration, thereby effectively characterizing Attorney Shockett's behavior as worthy of disbarment in the eyes of this judge.
Yeah, they've set him up as a trap. They're just trying to trap the bastard into jail and back into prison. So yeah, that's what they're doing. It's a big conspiracy to trap him. Mel Klump with the $10 says Megan on Viva Frei yesterday was ellipses.
I don't know what that means.
It was.
It just was.
Oh, but Diane's got a response for Megan Fox.
Diane says, I love the Gen X vibe in here. By the way, what platform do y'all prefer we purchase our memberships and or make donations? It seems like YouTube keeps too much money because YouTube is asshole.
You just, yeah, all right.
YouTube is
Mark that up
asshole.
mark that up on your card, people.
What platform? I like locals, meganfox.locals.com. I think that's the best place for memberships because I put exclusive content there and we do other things there and we have live chats and memes. It's $5 a month and they are really good to us over there. Locals is really, really good to me. I think Jeff has a different YouTube memberships, right?
I like you. My YouTube memberships are the only memberships I have. And donations, I mean, super chats are the official YouTube way of doing it. There are other links down in the description. Just go to YouTube. Shh. There might be other possible links somewhere to Cash App, Venmo, PayPal.
Are you not allowed to? Are we not allowed to tell you?
No. Yeah, super chats. YouTube does not like it when you tell them how to get money to other people.
I didn't know that.
Yeah. That's
what is it? That's
business. A violation of terms of service. That'll get you
what?
checked. Yeah.
I usually have it running across the bottom of my screen. I never knew that was I didn't know that was a violation of terms of service. No clue.
They've got to find it first.
I'm
just being extra careful these days for me.
I had no idea. Can you get hit for violating terms of service you didn't know existed?
Ignorance is no excuse.
Yeah, I guess.
You should know that following all these law things you follow. But Mel Klump says, This is the conclusion of the Megan on Viva Fry yesterday was fabulous.
Oh, thank you so much. I had a good time. I'd never been on with him before, and it was good. I was nervous because he wanted to talk about this new Russia hoax thing, and I was like, "What Russia hoax? I have no clue." But it was pretty interesting. It's this DOJ indictment of Tenant Media, 2 people at Tenant Media for allegedly being Russian spies and using conservative creators for pushing out content. And I'll tell you what, Jeff, it scared the crap out of me. I don't think I'll ever work with any company ever. Like I'll just, how the hell are you supposed to know what's a front company and what's not? You know, I don't know how you get that information. They gave these people the name of a guy who doesn't exist. Some billionaire who doesn't exist. And they're just sending checks to Tim Pool and whatever. And, but it does seem like a strange setup. Anyway, you should read about it. It's interesting.
I will. And in case you've you've renewed your bingo card, check off passive aggressive pause again. Back on track. With paragraph 16, the Gosneys filed their first and second motions to disqualify Judge DeThomas for bias in both cases. And the orders denying those disqualification motions were entered in both cases. The Gosneys' petition for writ of prohibition flagged both lower tribunal cases, explaining that a writ was needed to remove Judge DeThomas from the civil case because it was still ongoing. The first disqualification motion, and certainly the second one, as well as their petition for writ of prohibition, amply detailed Judge DeThomas's improper conduct and improper comments that gave rise to the Gosneys' well-founded fear of not receiving a fair trial in their ongoing civil case, and provided ample authority for his removal from their case.
That this panel instead dismissed the Gosneys' petition for what are you dying about?
We slowed it down a little bit there. I like that. we're both at 0.75 speed now. Continue.
Hold on, I have to yawn. I'm so tired. I don't know why I'm so wiped out this week, but I am. I'm today. It's just the week caught up with me all at once. You ever feel like that? Like my eyes still. When I woke up this morning, I tried to open my eyes.
This damn thing again.
And they were burning.
Oh, I hate that. Yeah. You're just like tired and your eyes just start burning.
Yeah, like that's my eyes this morning. I was like, oh God, I can't do this. All right. I am on 18, right?
Yes.
That this panel.
Whoa, hang on. There we
Whoa, Jeff.
What? Psych.
Stop it.
I just brought up the 954-page appendix just in case for when we need it. Now I can't put it back. Go back there.
That this panel instead dismissed the Gosney's petition for writ of prohibition suggests that perhaps it misapprehended the interrelationship of the two cases, and that one case is still ongoing and will not be remedied by the appeal in the other case. A writ is therefore necessary to forestall present impending injury caused.
There we go. Passive aggressive pause. I said it.
Caused by a biased judge
There. That worked out.
who has already adjudicated material issues in a case that were not even before the court, and who has already expressed his opinion that the Gosneys and their attorney are untrustworthy and engaged in unethical, nefarious conduct.
And see, he's kind of repeating himself just about every other paragraph, but it's necessary because it happens so often in such an important way. You've got to tell them again, and then tell them what you
Tell
told
them a
them the
third
first
time.
Yeah. Well, the motion for consolidation with this other case. On rehearing, an appellate court has the authority to consolidate related cases under review for opinion purposes. See this case here.
The Gosney's direct appeal of the final order of April 18th, 2024, dissolving the injunction is pending in this court, and the initial brief is to be filed in mid-September. Oh, that's coming up. That's like next week. Between the overlap of facts and issues in the two related cases, as well as the larger constitutional concerns of due process and the right to an impartial tribunal, which are in play here, it is in the interest of justice for the court to rescind its preliminary dismissal of the petition for writ of prohibition, consolidate it for opinion purposes with a direct appeal in case number whatever, and consider both matters together.
Great. So they want to consolidate these two cases and have the court hear them both. Sounds reasonable. That way you don't have to have two hearing dates for two cases involving the same people and essentially the same things.
I hear dog panting.
Yes, you do.
I knew
Jack's mom with the $2. What does it sound like when a gun goes off 3 times? Blam, blam, blam. Maybe. I don't know. Oh, hey, look, we get a mark off a square on bingo.
Blam, blam, blam.
Weird coincidence.
I think I need to make a t-shirt that just says blam, blam, blam. With like a comic book background, you know, like with the like you would see in a Batman comic.
Yeah. Kapow.
And you can just know. People will just know. Yeah, that's a Levy County t-shirt.
Yeah.
Maybe it should say, "Welcome to Levy County."
Oh,
Blam,
dear.
blam, blam.
Oh, dear. Where are we here? Okay. Doing so, for one thing, would allow the court to fully appreciate the wholesale lack of support for the disparaging findings. Oh, I like this paragraph. If they consolidate the cases, this court would be able to fully appreciate the wholesale lack of support for the disparaging findings which Judge DeThomasis made against Attorney Shockett in the April 18th order, and that they are nothing more than the product of the judge's personal bias and antipathy towards this attorney that began months prior in Hales v. Preston.
Yeah. Yeah, bring that up. Make sure they know to look at that case.
Yeah.
Motion for rehearing en banc. Decisional uniformity is so important that it is one of only 2 grounds for en banc review. The other involving cases of exceptional importance, Rule 9.331, Mitchell v. Brogdon. En banc review is the primary tool for reducing is it disparate or disparate? Big words. Check off big words. How do you say it?
Disparate.
Disparate. For reducing disparate results.
Of course, I also say voir dire as voir dire, the way God meant us to pronounce it. So, you know, take my Utah pronunciations with just a little grain of salt.
Okay, well, I don't use the word disparate very often, so I don't know how to say it. En banc review is the primary tool for reducing disparate results within a large appellate court arising from randomized panel assignments and specifically utilized for interdistrict conflicts.
On August 7th, 2024, a panel of this court rendered its decision in the original proceedings of Hales v. Preston and issued a writ of prohibition against Judge Craig DeThomas's for the
How did we
unlawful...
miss that footnote?
Oh, I don't know.
Where was it?
I don't know. Anyway, Judge DeThomas's findings regarding Attorney Randall Shockett in his April 18th, 2024 order were of such a repugnant nature that they could potentially end any attorney's career if they were true.
That's true.
Correct. If you're setting up an opponent to be thrown in jail, if you're fabricating grounds for a violation of a protective order that will send someone to jail, that's a disbarable offense.
Yes, it is.
All right, so they rendered the decision in the original proceedings of Hales v. Preston, this same court here, and issued a writ of prohibition against Judge Craig DeThomas's for, quote, the unlawful exercise of judicial functions, which are very similar to those which occurred in this case. Attorney Randall Shockett is also lead counsel in Hales and bore the brunt of Judge DeThomas's repeated and unfounded castigations until the judge was removed from the case by a panel consisting of Judge Bilbrey, Nordbay, and Tannenbaum.
In other words, the good judges.
Yes.
Those of you who are
Smart
reasonable. The smart ones.
Smart judges.
Although the panel in the instant case is different and not as smart, the commonalities and similarities between Gosney and Hales are so striking that the outcome should have been the same. Actually, I would have said that it was worse.
Yeah.
He has been worse in this case.
And Portland don't just writ. It's right, Jeff. Duh. It's like when the Simpsons got their exchange student. Oh, Mr. Simpson, you are so learned. It's learned, boy. Learned. In Hales, the panel found that Mr. Hales, quote, demonstrated a sufficient basis for disqualification in possibly his second, but certainly his third motion. Hales' third motion to disqualify, written by undersigned counsel, encompassed and detailed certain issues concerning inter alia, Latin, for among other things.
Oh.
Mark off Latin.
I can get Latin now.
Encompassed and detailed certain issues concerning inter alia, Judge DeThomas's repeated, unfounded denigration of Hales' attorney and the hostility he displayed towards them, including gratuitous cross-examination and interrogation on collateral matters. Hales' third disqualification motion also addressed Judge DeThomas's lengthy accusatory order denying Hales' second disqualification motion as being an independent basis for disqualification.
In the instant case, not only is there an undeniable continuation of the same pattern of judicial misconduct and unlawful exercise of judicial functions by Judge DeThomas's, it's actually worse. Surely it could not have escaped. So here we go.
Yep,
so she did.
She
She did. Surely it could not have escaped the panel that Judge DeThomas's not only took on the role of attorney for Mr. Griffith in interrogating counsel, not to mention in an unbalanced fashion, but the judge even became a witness for Mr. Griffith when he chimed in to answer on behalf of one of Griffith's attorneys, Kirchhoff, who hesitated for a long time when asked a question posed by Attorney Shockett after the judge placed Kirchhoff under oth. Here's the problem. Clearly, Randall and others in his law firm are they're not Star Trek fans. Otherwise, they would know it's Kirk out, not Kirk off. That's what we should have been calling her. Kirk out.
Kirk out.
Not only was the judge's answer wholly non-responsive to Shockett's question, the judge never made Attorney Kirchhoff answer that question directly. Yet Judge DeThomas has made highly prejudicial findings against Shockett in his April 18th order based on his own contrived and slanted inquiry. Oh, this is so beautiful.
That's very good writing. That
beautiful
is
paragraph, Doreen. Very well stated.
Second bingos.
Nice.
Well, what happened in this case is no different than what we saw in Hales. Judge DeThomasis cannot keep from switching roles between being an attorney for one side and then going back to being the judge again. And it happens often, such that justice and fairness become a game of heads I win, tails you lose. That is exactly what happened here. And the flash drive with the recording of the April 12th hearing and the hearing transcript immediately bear that out. There we go. Watch the video is what they're saying there. Just watch it. Just plug in that little flash drive and give it a gander.
Additionally, the written order of 412 denying the Gosney's first motion to disqualify states it does not establish such a factual foundation which would prompt an objectively reasonable person to fear he or she could not get a fair and impartial trial. While that order may not have consisted of over 2,500 words, like in Hales, that sentence alone shows that Judge DeThomasis took issue with and attempted to refute the allegations in the first disqualification motion, which is an independent basis for disqualification, as also noted in Hales. Further, as it pointed out in the Gosney's petition, Judge DeThomasis most certainly did take issue with the first motion to disqualify orally on the record, and is also a basis for his disqualification.
That was just an awkward pause for no reason.
This will get awkward.
And Jill Ems asks, is Blam Blam the second son of Barney Rubble? And for
Blam.
Megan Fox.
Welcome to Levy County. Pixar, it didn't happen. Thanks, Daniel, for the 5. Appreciate that.
And back to live. The prejudicial accusatory language and pernicious. Ooh, there's a good word. We don't use pernicious nearly enough anymore.
We do not use that word nearly enough. That's a good word.
And by nearly enough, I mean never. We should bring
pernicious back.
It's pernicious that we don't say pernicious enough. The prejudicial accusatory language and pernicious characterizations directed at Attorney Shockett in an order of April 18th are no different than what this judge directed at all of Hales' attorneys in his 2/14/24 order denying Hales' second disqualification motion. Both orders contain a running diatribe of unfounded, unsupported attacks against Randall Shockett and his clients. This record reflects that the April 18th order is nothing more than a byproduct of Judge DeThomas's obvious personal bias against this particular attorney, Randall Shockett, which began in Hales and carried over into Gosney.
It is appropriate for a court to issue the writ of prohibition in emergency cases to forestall an impending present injury. Hales v. Preston. This record clearly shows that as long as Judge DeThomasis continues to preside over the Gosney's ongoing civil case, present injury is not just impending, it's certain. For purposes of decisional uniformity, therefore, particularly in light of the August 7th opinion in Hales v. Preston, petitioners respectfully request that this court grant their motion for rehearing en banc.
Cool.
So is the motion for the rehear, like,
yes,
for them to rehear?
Yes.
So that means that they have the ability to accept or deny it.
I guess, yeah.
That's kind of nerve-wracking because if they deny it, it's over, right?
Unless the Supreme Court wants to deal with it.
Oh, right. You'd have to go to a higher court, right?
Yeah, the state, I guess the Florida Supreme Court.
Frankly, though, I don't know how they couldn't look at this and be like, I think we screwed up here. Because she's quoting them to themselves from the Hales case.
But then again, you have to get judges to say, we made a mistake.
And that's always very difficult. Yeah.
Wherefore, petitioners respectfully request that this court grant their motion for rehearing and for consolidation, or alternatively, their motion for rehearing en banc in light of the foregoing points and arguments, and order all such other relief as is proper and just. Well, that is the end of the prepared phase of our evening. We currently have 1,008 people here, 400 on me and 600 on her.
Yep.
That sounds like a party. Well, so we can either just send you all leaving and scurrying about your business 30 minutes early, or we can spend 30 minutes reading some fun transcripts. What may be fun transcripts and could be horrifically
We're not sure. They could be very boring. Boring.
And there's
All right,
only 954 pages to choose from.
While you in the chat figure this out, the court's going to take a comfort break.
Awkward pause. Oh, look, Yoda's running in his sleep. All right, Peep. What do you think? If you want to hear us, I guess what we would be reading would be transcripts from a. Let's scroll down here and see what it is. It would be transcripts of an injunction hearing before the Honorable James T. Browning, acting circuit judge. So this would be the hearing regarding the injunction order itself. Probably the hearing that to make the temporary order permanent. So if you want to hear that, put a 1. If you want to just go away, put 2. Put a 2 in chat. One to do the 30 minutes of transcript reading, and 2 just to go away. And while she's gone, we don't want to make her feel bad, so we'll do this while she's gone. Well, that was the wrong button. That's the one I wanted. Thank you very much, Just Dawn, Soulless Ginger, for gifting 5 Legal Vices memberships. If you happen to be Jiraiya, J Cares, Urza. Hey, what's up, Urza? It's been a minute. John's Collection and Melly Cormier. Welcome. You guys got your free Legal Vices membership, and we will probably 2 weeks from tomorrow be having our next our September members only stream. So please stand by. Megan's back, and all of the ones in chat tell us that they want us to read the transcript.
Oh, good. Okay.
Susan said 2. Well, I hope you'll stick around anyway, Susan.
Everyone but Susan wants to. Yeah. That's okay.
Jiraiya said 2. You just got a free membership. Where are you going? Stick around. You're obligated to stick around here now. Squid Pro Quo only needs 21 subs to monetize. Well, throw down Squid Pro Quo's link there in the chat, and people go on over
in
and
the chat.
Squid Pro Quo's funny.
That's awesome. Only 21.
21.
I've been meaning to join her one of these days too. I just got to get it on the calendar.
And Megan, what's your next sub goal?
Oh, well, I'm trying to get to 50,000. And right now I am at, let's see, where are we at? 176. So we're getting there. I had a really hard time getting to 45,000. It's like those milestones are just like, they keep unsubscribing people, and so that you can't hit them. It's really strange. Yeah, and then as soon as I passed 45, it started going up again. And it's been going up pretty steadily. So we'll see if we can get to 50. That would be great. So if you haven't subscribed, do it.
Get Megan to 50K. Denise Sells, who's been a member for 4 months, says, please pin Doreen's article.
Oh, I actually don't have it on my computer. Do you, Jeff? I have it on my phone.
I have it on my, I don't have the link to the article. I just have the article.
Well, how do you have that? Okay, I have the link. Let me send it to myself, and then I can.
Maybe I have the link. I don't know.
I have the link.
All right.
I thought I sent it to you. What I'm going to do is I'm going to send it to you on Twitter, and then that way we'll both have it on the computer, because I have such a difficult time doing this. My phone, because I don't have a Mac anymore, my phone and my computer don't talk. And that's always, and so if it's on my phone, it's like a whole thing. Stupid.
Squid has 497 subs, just a few more. And there's a car with no muffler idling outside the building here.
I hear that. I didn't have that on the bingo card, though, unfortunately.
It just sounds like someone blowing into a bottle. Just.
All right. I just sent it to you.
Cool.
All right, good. I will put the link to this in the description of the video. I'll put that in there now, so it'll be up there. And I can also drop it in the chat.
Groovy, please do. All right. Well, JKD Books is legal advice to move to Indiana. No. See, this is the thing. The weekend here, this is the only bad part of summer from now. What time is it? Around midnight, 11:40 p.m. until about 2 a.m. There's this beautiful bridge where if you saw the movie Black Panther, when they came to Busan, Korea, as part of the movie, and they filmed this car chase scene with Black Panther on top of a blue BMW fighting on a bridge. That bridge is right outside my window. At the beginning, when you're watching Black Panther, the first one, and it says Busan, Korea, if you watch it in these full cinema aspect ratio, my house is in that movie. So that bridge from Black Panther where he's on top of the BMW having a big fight scene, that's right outside my window. It's about 3 miles.
Oh, that's cool.
Long. Yeah, it's about 3 miles long. So you get the supercars, the people that have the McLarens and the Ferraris. They've got nowhere to run those. So they wait till everybody goes to sleep on a Friday night, and then they just run back and forth on the bridge for about 3 hours. And so it just sounds like back and forth, and it's they idle outside here for a little bit. So anyway, that's enough of what's outside my window. Let's talk about Judge for a minute. This is the deceased Judge James T. Browning. So he's not the bad judge. So we don't have to do evil judge voice for him.
All right, who am I going to be?
I don't know. Let's see. This is the transcript for the injunction hearing from 2019, September 11th, 2019.
Oh, the one that they got it granted. Oh, this should be interesting.
So who's appearing here? Appearances. Okay. Court, parties. Gosney. Do you want to be Gosney and Griffith? We got court. Gosney, Griffith, McAuliffe. You have to be Ms. McAuliffe.
I'll be Ms. McAuliffe, and you be the court.
Okay.
And I'll answer the other. I'll be the others, I guess.
All
That'll
right,
work.
Court. I'll be Court, Gosney. You be Griffith.
And McAuliffe. Okay.
But McAuliffe is going to be questioning. God, there's too many people here.
Too many people. I can get out the voice changer. Wait, let's see. I have my Sally Smith voice at the ready.
So the petitioners are the Gosneys.
Or my Reddit voice.
Okay, McAuliffe works for the Gosneys. So I'll have to be Gosney and you have to be McAuliffe. And Jones is for Griffith. Oh, Jesus.
What's the problem, Jeff?
I don't know. Just stop taking the testosterone.
This is my Sally Smith voice. I like kidnapping kids from parents at hospitals and accusing them of child abuse when their kids are sick. It's just a thing I do.
Great. So you be Ms. McAuliffe, and I will be the Gosneys. And
who's going to be Griffith?
Do you want to be? Do you want to be the court or Griffith?
Either one. I don't care. I'll be the court. You be Griffith. Okay. You're funnier as Griffith.
Potentially. All right. Bronson, Florida, Wednesday, September 11th, 2019, 10:03 a.m. The following proceedings were conducted, the petitioner and respondent being present.
Next case the court's going to call is William Gosney versus Philip Griffith. And again, counsel, if y'all want to use the table, that's fine. Versus the podium, y'all can have a seat, that's fine. Anyone who may be testifying today, raise your right hands, please. Oh, that's a lot of people.
Okay, that's really weird. That's really, really weird. But all right.
Should I be Joe Biden instead? Because that was really funny.
No.
You don't want Judge Biden?
Why ever not? Come on, Jack.
Just awkward. Please read the court here.
All right. Are you Mr. Gosney?
Oh, you're not going to do the court voice?
You said it was weird.
Well, that doesn't mean don't do it.
Oh.
Okay.
That's weird.
Are you Mr. Gosney?
I am, Your Honor.
And your name, ma'am?
Brenda Gosney.
And your name, sir?
Phil Griffith, motherfucker. Your Honor.
Did any other counsel, is there pending criminal charges in this case?
Here, Ms. McAuliffe.
Yes, Your Honor. The state of Florida filed a couple days ago aggravated assault with a deadly weapon, improper brandishing firearm.
So the charges have been filed?
Correct, Your Honor.
And it's Miss McAuliffe. Is it Mr. Jones?
Yes, Your Honor.
And your client's aware of his Fifth Amendment, I'm sure.
That's correct, Your Honor.
The right to remain silent. Okay, that's probably why he didn't raise his hand. Thank you.
And I would like to ask the court to take judicial notice of the court file in 19 CF 566.
Or was that Miss McAuliffe 19 CF 56?
CF 566.
Don't interrupt me. Was that 19 CF 566?
Wow.
Yeah, yes, Your Honor.
Wow, we're off to the races with this judge. Jeez.
Thank you. I don't say that to interrupt you. I say that because it'll break my train of thought and I won't hear what you said and then you won't hear what I said.
Yeah, yes, Your Honor. I understand. And it doesn't help the court reporting when they try to type it up.
Yes, ma'am. Give me just a second to read this. Okay, Miss McAuliffe, beyond the facts as contained in the petition, what I don't want to do is go from, well, we don't need to reinvent the wheel. I see what's Mr. Gosney, is everything that's contained in this petition true and correct to the best of your knowledge?
Yes, Your Honor, it is.
Okay, you don't have to stand up, that's fine. Is there anything additional to the petition that you want me to consider?
I keep forgetting this is me. There is one issue. My understanding is that that at this point the other side is not intending to object to the injunction, other than to one.
Is that correct, Mr. Jones? Interrupting.
Yes, Your Honor. If I may address the court.
Absolutely.
Sir, I represent Mr. Griffith on this criminal matter.
Yes, sir.
So on the 10th of July, he was arrested, and I went to his first appearance. Judge Davis was the judge. Unfortunately, why we're here this morning is that they're neighbors. And so I explained to Judge Davis the situation. He waived the 500-foot buffer rule for the criminal case. A couple days later, this injunction was filed. In the injunction, the 500-foot residential residence buffer rule was in the injunction, so Mr. Griffith has been displaced. He is now charged with a felony case, which is now pending. We're intending to litigate, so we're not contesting the injunction. We are stipulating that the court can enter the injunction. I see based upon the allegations, there's enough for that. However, we are objecting to the 500-foot buffer rule, and I do have legal arguments to make for that reason.
Miss McAuliffe, are you objecting to that?
The 500 foot?
Yes.
Correct. Yes.
Okay, let's hear your legal argument then, Mr. Jones.
Okay, for those who don't know what's going on, as he mentioned, they've given this protective order against the Gosneys. I mean, against the Griffiths, and they have to stay at least 500 feet away from the Gosneys. The problem is he lives less than 500 feet away from the Gosneys. So his lawyer wants to get an exception to the 500-foot rule so that he can live in his own house next door to the Gosneys. And here's his arguments.
That was almost Muppet voice. It almost.
Yes, Your Honor. So, and I do have testimony if the court needs it, but my client lives at someplace we're not going to read. The petitioner lives somewhere else. I believe that the temporary injunction does not take into account the unique situation of the parties. I have two cases for the court's consideration, if I may.
Absolutely.
Hand one.
Give them to the lieutenant.
You gave me one. Oh, sorry.
You gave me one.
Miss McAuliffe, do you have copies of those case law?
I do not. Thank you. Oh, now I do.
And
I always like it when people highlight what they want me to consider.
that means he doesn't have to read the rest of it.
If you can just direct me to the case and where you want to direct my attention.
Yes, Your Honor. So Givens v. Holmes, if I may just make a rundown for the court.
Sure.
This is a stalking injunction. There was no testimony taken during the actual hearing. The court granted a 500-foot injunction rule, and the respondent appealed it. I would say on page 3 of the actual case, and it's the second full paragraph where it says, Mr. Givens contends that the final portion enjoining him from 500 feet prevents him from accessing and using his property. He tells us that the parties live approximately 90 feet from each other. He thinks that any restrictions would render him unable to access his yard and residence. Therefore, he now asserts and buffer zone provided is overbroad and violates his fundamental right under Article 1, Section 2 of the Florida Constitution to acquire and protect property. If you see it, it references another case. Then the court says we agree. And the other issue in this case is that there wasn't a contemporaneous injunction or a contemporaneous objection to the court's ruling. I think there was no testimony taken, and if I may point the court then to the next page, or if the court just wants to continue reading, there's only one more page after that.
Give me just a second.
Sure.
I'm still reading the case, but is the parties like directly adjacent property?
They share a fence, Your Honor.
Well, okay.
And Your Honor, I do have
Wait,
to,
that's me. And Your Honor, I do have to help clarify. I have, and I was going to enter into evidence. I have a picture, which I've already shared with the defense, showing a couple of overviews of the properties to show where exactly, because all of these issues are arising in one small section of the property, which is why, and I actually offered counsel, hey, come up with a 10-foot, 20-foot, 30-foot something, because there's one, what I call this hot spot on this property, which is where an addition was being built by Mr. Griffith. There's been loud music. Multiple other neighbors are actually here. Many complaints. Many complaints have been going on from the beginning of this year.
I'm not here about music.
Yeah, yes, Your Honor.
And I'm going to object, Your Honor. She's had time to amend her complaint, and that's a separate issue.
Yes, we're addressing what we're here today, but there's one section in the house. And it's in the back corner.
Okay,
and I'll pass it to the deputy.
Sustained. Just let me see the pictures.
Yes.
Have you had a chance to review them, Mr. Jones?
This is like watching Sybil. It's like the three faces of Megan.
I went to theater school for this.
Now, I don't remember her providing them, Your Honor, but
Go ahead.
If I may just have a...
Yes?
And if you have pictures, Mr. Jones, that...
Yeah, I think they show...
You want me to take a look at, I'm happy.
Well, yeah, and just the color photographs. And I'm going to give counsel a copy as well. This is pictures from my client's property, just so the court can have...
Okay, okay.
The two black and white ones.
Miss McAuliffe, you're black and white.
What? I think there may be an error in the transcript.
She's like, the black and white ones. He's like, you're black and white. That's what my teenagers say to each other. Like, your mom's black and white. You know? Like, what the hell? Oh,
God. Mr. Jones, you're the color photos.
What was that noise?
What is happening in this court?
I don't know. I'm just waiting for a chance to say something.
It's your turn now. I'm talking to Mr. Jones. Answer the fucking question, Jeff.
I'm too busy laughing at your black and white. No, you're the colored one. Yes, Your Honor.
Y'all can have a seat. Ms. McAuliffe, you indicated a hot spot. What?
Yes, yes. If you look at where the addition is on the back side of the house you can see a partially built addition right by the swimming pool.
Is that the respondent's house?
That is the respondent's property where the pool is and the built addition, partially built addition are. And the petitioners, obviously, you can see the closeness of that fence line. And I will say that after the arrest of the felony charge, then I understand the pool was ordered previously, but the location of the pool was then put in the following weekend. And then, of course, the respondent has not been back to the property because the injunction has been in place. All of the escalations, etc., gun issues have occurred on that back corner, which is why when I suggested to opposing counsel to try to come up with some physical way to keep these two parties, and my suggestion was, because you can clearly see it, the front of the house on the opposite side where my client said there was a space there that the pool could have been placed, they said no, that wasn't where they wanted to have the pool. But the closeness of these two parties and the use of the gun, and of course, it does seem feasible that, obviously shortening the distance to be apart, but that does not seem that it would be feasible. And I don't know whether they finished their argument, but the issue I see with the cases provided, they don't give any facts into the background of the cases, which
No, I'm just talking about this photo.
Yes, well...
And I'm not getting into anything else.
Okay, I won't make arguments.
Mr. Jones.
If I may.
Anything that you want, you can respond to her.
Sure.
And also anything you want to take to note in your photographs that you provided?
Yes, Your Honor, they do share a pool. Or excuse me, they do share a fence. Don't share pools. That apparently from what we know recently, sharing pools and hot tubs never leads to a good conclusion.
Oh my God.
The issue
do
where
not share pools or hot tubs.
No. Just bad. The issue where they're talking about this hotspot, it's an addition that my client's working on. He's a licensed carpenter, and it's basically sitting unfinished at this time. If we're going to talk about negotiations, they're saying if we moved the pool, they would have agreed to something, which doesn't make any sense to me. The pool was done right. They applied for a permit. It was granted a month before they installed it. It has nothing to do with these actions. And again, I would just say that allowing the 500-foot rule violates his constitutional rights. This is his only property. He's had to, since his temporary injunction has happened, he's had to live in two places. And so not only that, it's a financial hardship. Their house is unfinished, and he has to pay 2 rents, Your Honor, which is why you're making, we're lodging the objection. And additionally, he has not violated the court order
That's what I'm about to look up.
In the felony case. Now, let me say for the court, just to be upfront with the court, when he was served with the initial injunction, the deputy, apparently my client, didn't read it. Oops. He stayed at his home. The deputy that served it to him did not tell him. Later, I believe the petitioner called when they saw him in the backyard. The police showed up, and if you can see, there's a misdemeanor case pending. They said he immediately grabbed his clothes and left, and has not been back to the property since. Additionally, the petitioner has multiple security cameras that do have both audio and visual recording ability that is trained on my client's property at all times. So I just want to let the court know about that as well, because I don't think that's in the petition.
And
hold on a second. I'm looking at something else on my computer.
I don't think this judge likes her very much.
Mr. Jones, how long was it that your client had stayed there unaware of the 500-foot rule?
I think, if I may, Your Honor.
Sure.
It was the same day, Your Honor.
Same day?
It was the same day, Your Honor. He was not arrested when the deputies saw him. They gave him a notice to appear.
And does either counsel, Mr. Jones, do you know whether your client has any previous criminal history?
He has none, Your Honor.
None. And let me get back to Ms. McAuliffe. Can you tell me, I can look at I brought it up on my computer and I can read the information, but in the body of the petition, I see 2 separate incidents occurring, one on July 8th and the other on July 10th.
Yes, Your Honor.
Or is there 1 count or 2 counts as it relates to different days?
In regard to the criminal case?
Yes, ma'am.
The criminal case is to the incident on the 10th specifically.
Okay, Mr. Jones, as law enforcement, what's the I'm sure the first appearance, without looking at it, said there's a don't possess any weapons or firearms. What's the status of your client's firearms?
They've been removed. They're with a friend, Your Honor. They're not in his possession. And Your Honor, there was also a BB gun. I've instructed my client to take that out of the house as well. So there are none of those as well.
And you provided me with 2 cases. Smith v. Walker. What do you want me to consider on that?
That one, Your Honor, the court ordered.
And did you highlight it? I didn't look.
Oh, I apologize. I didn't want to.
No, you did highlight it. Oh, you did. You did.
Oh, I did highlight? Okay.
Yeah, I said it before I looked.
I must have given you my copy. But I apologize, but.
Do you need your copy back?
No, Your Honor, but basically the court ordered the respondent to stay off his driveway. And the ruling by the appellate court was that it prohibited the respondent by exercising lawful activities on his own property. And thus that restriction on his property was improper. So we also think that case applies in this as well, Your Honor, because he's not only living at his house, but he's doing improvements on it too that he will not be able to do, which are lawful.
Do either one of these cases that provided me, and I haven't read the entire case, and it probably will take a few minutes to go back to my chambers and read them. Does either of them have the underpinnings of a criminal charge against the defendant or respondent?
Not that, well, I don't think so, Your Honor. I mean, let me say that I don't know.
Okay.
Because they're yes, I'm not. I don't have that answer for you.
And then if before the court would consider, can I make just a comment about the 2 cases? I'm just looking at them myself right now, but the distinction that I clearly see is that the court has got very broad parameters, especially in injunctions, because you're looking at the safety of the petitioners here. And the courts are being informed that injunctions to be specifically tailored to each case, to not infringe upon conduct that does not produce harm sought to be avoided. And I would say that in this case, we should be following the statute to the letter, because I mean, there's no more egregious conduct, that an escalation to the point where, firearm has been used. There has been threats, multiple threats. And they're conceding that there is obviously the need for this. And these
Megan, do me a favor.
Hmm?
Read that last sentence with your Trump filter.
But it sounds so bad on me. I actually don't even have it on the stream deck because it doesn't sound like him. You should you should do it.
Well, I don't have my board anymore because I've upgraded to the Rodecaster. But anyway.
I don't use it because it doesn't sound anything like him, and it just sounds weird.
That would be good. It's like there have been threats, multiple threats.
Multiple threats.
All right, continue, please.
And they're conceding that there's obviously the need for this, and these 2 incidents do at least, and there were other incidents, but these 2 meet the requirement for that, which is why they're conceding. And my position would be that it's up to the court to make the determination. And one concern that my clients have, that when the respondent becomes out of control, he gets very agitated. And right now, he's got the felony case hanging over him, which they, seem to be the cause of. So they are very concerned about retaliations. And I would also point out that someone who's served by a deputy with an injunction telling you, clearly coming from a court, something very strict, that you don't read it, and it very clearly says you have to leave and ask for clarification from the deputy, that you simply go, he doesn't read it. So our position is that we actually have, didn't want to go through, and I understand that's why they conceded with the testimony from all these parties. There were several complaints made prior to with what they believe were the right channels, and they didn't have.
Can anybody hear the dog snoring?
Oh crap! I missed the dog snore.
No, well, if you'll stop talking and listen. No.
There it is. I heard it.
Okay. I hear it, so that's all. Mark off dog snore
on
your bingo card. Dog snore. All right, Your Honor. Again, I'm going to object on this. This is improper. I think what's in front of the court right now is the petition, and so again, she's alleging other things that I think are not covered by the petition.
It's in the petition.
Overruled.
Yeah, The petition clearly says that code enforcement and law enforcement were previously called, and they get to this point of escalation when actually now we end up with an arrest and potentially could have been, gunshots and injuries to parties being my clients. So I would say that this is clearly in these two cases, while they remove the 500-foot injunction on these, we don't know if there was texting. If there was, too many texts, we don't know anything about the underlying cases, and we certainly don't see anywhere that it says there was a criminal case involved with firearm also involved.
Any response, counsel?
Well, just to go back to my earlier argument that Judge Davis heard the allegations, Your Honor, and he still waived the 500-foot rule. The criminal judge did that. Initially, there have been no allegations of contact between my client and their client. And so I want to make that clear to the court.
Okay, so Judge Davis waived the 500-foot rule.
Yes, and so after he actually was released on his own recognizance. After he was released, he went back to his house and lived there until he had to leave once he found out about the 500-foot rule. And even in those days, once upon a time, he still was able to install the pool. Which apparently the petitioners have a problem with, without any problems with the petitioners. So that's what I'm saying is if they're making this argument that they don't know what he's going to do, this case has been pending for 2 months and there's been no contact.
And he's been at the house for 2 months.
No, Muppet voice, no. He left after the injunction, mother. Oh, no, he left after the injunction. So he has not been at the house since he's been.
Was that the one day you said he was there and there was?
Yes, but the injunction, he wasn't served with the injunction until I think 5 or 6 days afterwards, correct?
Okay. Everyone in the background, don't nod your head in affirmation or nod your head and disagree. Let me focus on what Mr. Jones is telling me.
The injunction was dated 7/15, Your Honor. He was released from jail on the 11th. And assuming he was served that same day, so he was there a matter of like 4 to 5 days, and there were no allegations of contact because he was following the court's order.
Was that an oral pronouncement by Judge Davis? Because I just see no contact.
I also have nothing.
On the first appearance order.
It was an oral pronouncement. Yes, Your Honor.
And I've received nothing supporting that.
Well, it's all recorded, so I can certainly go back and look at it. That was August the 11th. He was first appeared.
Yes, Your Honor.
Was that in Gainesville?
It was in Gainesville. I believe it was a Saturday or was a holiday or something. I forget off the top of my head.
What I'm going to do is I'm going to take a few minutes to read these 2 cases, and then I'll come back and I'll take a look at the first appearance recording. So anything additional you want me to consider?
No, Your Honor, and the court's going to review the cases. I just want to say whether or not they're criminal cases, it speaks to injunctive relief, which is
I understand
what they're asking for today, and so they're applicable.
Is there anyone else? What's the nature of the testimony that your witnesses or do I not need?
I was anticipating just depending on what they were going to provide testimony to. But if this is all that's going to happen, we're not going to call those witnesses, Your Honor.
Okay, anything additional from either side? And don't repeat what you already said. Anything? Miss McAuliffe?
Yes?
Are you mulling that?
No, Your Honor. I just sort of...
Okay.
Well, I just wanted to, for the court's consideration, there's a 6-foot chain link fence between the parties. My client or my client's wife has already a wrap that would go on the fence to make it that it would not be see-through, Your Honor. They can't, because of their monetary situation about being in 2 households and my client is disabled, they can't just put up a 10-foot privacy fence right now. That's just not, but they're trying to make any effort possible. They've already ordered that, and they intend on installing that when it gets here.
The one thing, before I leave the bench and I read the cases again and review the first appearance, that can you address the allegation, if this is a kind of repetitive pattern of behavior?
Oh, I think that we have. I think that this is one of those neighbor disagreements, Your Honor, that's been escalating, and I think it's on both sides. I think that unfortunately for my client, he's been arrested. And, you know, this isn't the first time they've tried to get an injunction against my client. The last one was dismissed. So we agree. I think my client understands his most pressing issue is being able to live at his house, and he's willing to listen to the court's order. So I'm not disagreeing with that assessment of what's going on.
Yes, Your Honor, I would like to address two things since it was raised. The specific, and I had mentioned it, and the court didn't want to hear it because, however, it has now been raised by the other party. Both my clients had filed for an injunction at the beginning of the year based on the harassment, the loud noise, the cussing, the screaming, threats across a fence, etc. At that time, they actually filed it under they filed it under domestic violence. And the judge said, if anything else happens, come back. And maybe they did the repeat, but it hadn't escalated. So then at that point, and it's in the court record, I would draw the court's attention to the court file then, since it was raised. And I have a copy of it here if the court would like to, if it's easier for the court to have a copy of 19 DR 05. I believe it's 05 and 6, and specifically sworn
19 DR what?
Yes, DR 05 and DR 06. And that was January the 2nd. January 1st and 2nd, two incidences where the petitioner had sworn statements. They were threatened violence against yelling, shoot at the security cameras 3 times. Those were the threats that they would bring the family to beat them up, screaming at them with the loud noise, poisoning, saying they're poisoning the plants, threats outside the bedroom window. We remember that. We saw that video. And the sheriff was called several times. This was back in.
Was that withdrawn or denied?
Say it again?
The injunction was not granted.
The injunctions were not granted, and there was a note that just said to, if anything else happened more than the yelling and the screaming, to refile, which we have now had. This behavior has been ongoing and is escalated to where we are right now, which is why the parameters, our position is the parameters need to go in place. And we do have, parties here that were neighbors from a ways away, that the harassment of the noise and the screaming was going on for months and months.
Okay. Bottom line is the court is going to enter a permanent injunction, and I'm going to leave the bench to consider the 500-foot waiving that. I will be until the court dissolves it. It will be until it dissolves it. So it's until further order of the court. It's a permanent injunction. I'm ordering no weapons, no ammunition, no firearms, no contact. I'm ordering a mental health evaluation and treatment. Now I will go and consider the 500-foot waiver.
Who the hell is Mr. Fugate?
I don't know. He's one of those many people. The court was like, who are all these people?
Your Honor, if I may, is there any chance that you're going to need testimony after you come back from, well, technically it's code enforcement? Because if not, we'd have to be dismissed.
I can't.
I didn't call them, so.
We did call them. And again, it's going to depend on what the judge.
And for the record, this is Mr. Fugate on behalf of code enforcement.
Technically, it's code enforcement. Yes, sir.
Well, I've already issued the injunction, and the only thing I'm considering is the 500-foot waiver.
My position would be that I know me and you, we've talked. They have a lot going on. If needed, then I could do a modification. I could do something else to bring it back if I had to bring him back, but not to keep him here the rest of the morning.
You don't need him here this morning, correct?
Yes, thank you.
Thank you, Your Honor.
Excused. We will be in recess while I review this.
How much longer do we?
I don't know.
29:30.
How much longer do we have?
Okay, we've only got.
It's almost done. We're almost done.
This is the first transcript reading here.
Wow, I'm proud of us that we got through it.
Okay, we're back on record. It took me a little bit of additional time. I've had the opportunity to hear argument of counsel. I've considered the case law that's been presented, and also to review the first appearance. The problem, what took me so long, is I thought I was reading someone's bad handwriting as August the 11th, and it was July the 11th, so I had to go back to the file and figure out when the arrest occurred and when they first appearanced him. As Mr. Jones indicated correctly, Judge Davis did waive the 500-foot rule, so the court is waiving the 500-foot rule. You can live at your house, Mr. Griffith. But right now, if you're facing aggravated assault with a firearm, and I'm sure your attorney will instruct you, you're presumed innocent until proven guilty, but that particular charge carries a minimum mandatory prison sentence. So whatever grievance you have with your neighbor, whether it's justified or not justified, you're the person who's sitting in the breach. So when I say that you can stay there, you can't have any contact with him. You can't sit in out on a lounge chair and stare in his direction. He does not exist to you, nor his family. I don't want, and hostile contact can be verbal, it can be nonverbal, it can be by action, or it can be physical. You're to have no contact with him, direct or indirect, okay? Don't do anything to provoke him, because right now this is a civil matter, and I've granted the injunction. I do believe that it would be burdensome, and burdensome is the only one of the considerations of the court, the safety between the parties. Because just as easily as an allegation of one person drawing a firearm at another person, and as they appear to be the aggressor, I've seen other cases where the other person drew a firearm and the aggressor became the victim. So the bottom line is no contact whatsoever. You and your family have no contact with him whatsoever, Mr. Gosney. And again, if you have any concerns, then that is something to report to your attorney, but first to law enforcement, and they can take whatever appropriate action. Is there anything else? I'm going to return the photos. I've considered them. I don't think there's a reason. Does either party want those entered into evidence? I mean, it's just you've testified to it, so the parties are not indicating they want it entered into evidence. Ms. Gibson, are you preparing me?
I am. On the mental health evaluation, does it need to provide proof to the court in so many days, or?
He needs to provide proof of the mental health evaluation within 30 days. Anything else from respective counsel, Mr. Jones?
There is, Your Honor. Miss Gosney's not on the injunction. We're a little concerned that they're going to refile an injunction under her name and then get this other ruling, and then we're going to fight this out again. So in lieu of that, we're willing to add her to the injunction. I don't know if it's a little unorthodox, Your Honor, but I know they wanted.
Oh, hold the phone. So she did file. Well, unless it's objected
to. Well, to add someone to an injunction is seldom objected to.
Yes, and that was my request to the other side, that they had not objected if we would agree to the 500-foot ruling. My clients don't want to do that. So obviously, yes, that was a question we had for the court.
Well, okay then.
Yes.
I just think
we will put Miss Gosney also on the injunction. What's your first name, ma'am?
Brenda.
Brenda.
Yes.
Okay, and I think the spirit and intent of the injunction was certainly encompassed, Miss Gosney.
And we just don't want to have another hearing, and I think it's
okay. And you're agreeing to it?
Yes, Your Honor.
Okay.
That's right, Mr. Griffith. Yes, motherfucker. Okay. Okay.
Okay. Where is the criminal case at this time? Is it just in?
It was just filed on case management is October 23rd.
Okay, y'all can have a seat. We'll just be at ease until the attorney, not but Ms. Gibson finishes up doing the injunction.
And Your Honor, I do have another matter I have to attend to. Is it okay if I leave, or would you like me to stay?
No, all that's going to be, we're just going to,
Okay, I figured.
Give your client that you might want to go over it with him at the appropriate time.
Okay.
But no, there's nothing else that we're going to do, or I'm not taking any more testimony or anything.
All right. Thank you, Your Honor. Have a great day.
Yes, sir.
Oh, it's the Columbo moment. Oh, Your Honor, there is one more issue. I'm sorry.
Oh.
Mr. Griffith is already receiving mental health treatment. He sees a neuropsychologist in Gainesville. I have a name for you.
Well, then all you have to do is supplement the record. I'm not going to make him duplicate something, as long as he can provide proof to the clerk.
Notice of treatment?
That he's receiving mental health.
Yes, Your Honor.
Services.
I will. Thank you.
And everyone can receipt back. We have another case to do.
There you go.
And scene. By the way, so Judge DeThomas's reamed Randy's ass because Brenda Gosney apparently didn't file a petition in this case. Well, here's the proof that they added her to it.
Mm-hmm.
Remember?
Yep.
Oh my God.
What you're saying Judge DeThomas has made a mistake? Is that what you're saying?
Yeah, and he spent and wasted a whole bunch of court time reaming Randy's ass for it, just chewing his ass out. Like, well, she didn't file, you didn't file, you made a mistake, and this is all a mistake. You don't know what you're talking about. I hate this guy. I'm telling you, I don't say that very often, but my God.
Here's where the fun begins on page 49. Griffith's deposition transcription goes from page 49 to 460.
Holy crap. I can't wait. We really
pages.
do need to read Griffith's deposition with you in that voice. Yes, motherfucker. It's going to be hilarious.
I'll have to listen to his actual voice a little bit more. People, listen, we had a lot of people. We still have almost 1,000 people. We've got 935. So nice. we only lost about 70 during that reading. So so from that, I'm going to assume that at least both of our chats were at least mildly amused by the reading of the transcript.
I know I couldn't look at the chat, and I will have to go back later and see what the reactions were, because it's hard to do that, especially when you're doing two different voices and also see the chat.
And I've just noticed I'm still talking like this for some reason.
At least it's not your Elaine voice.
Lindsay's like, I'm late. I was like, who's this dude? Oh, that's just Megan.
Somebody said I sound like a well-hung black man.
Wow. Okay.
Which is, I don't know what I sound like, because I also can't hear myself. I can't hear it till the replay. So I have no idea what it sounds like.
Oh, it's terrible. Stars, Megan,
sure
we're
it's
just listening
awful.
to you and talking food.
Oh.
Well, it seems like people, they stuck around. I'm sure they're wondering what the hell they're sticking around for, but hey, they stuck around. And while Megan tells you a little bit about her and why you should be subscribing to her channel, I'm going to find a place to send us all.
All right. Well, come on over and visit me over at my channel, Megan Fox Writer, on YouTube. I'm also on Rumble. Megan Fox Investigates over there. meganfox.locals.com. You guys can find me over there. I am going to be covering in the next couple of, next week probably, we'll be covering more of the Laura Owen saga. There's police body cam footage to get through for the FBI wellness check call that was made on her when she reported Dave Neal to the FBI. She told them that he made her want to unalive herself. And then the FBI sent the police to her house, and there is body cam footage. We're going to go over it seriously soon. I just don't know when. Maybe this afternoon. I might actually do that this afternoon. We'll see. But yeah, check it out. Subscribe, like, and make sure you do the same for Jeff, because if you're on my channel and you haven't subscribed yet to Legal Vices, I don't know what you're waiting for. Please get over there and do that.
Yeah. And we Megan and I, we need to keep moving in the right direction.
Yes.
Subscriber wise, and you all make it possible. And speaking of making things possible, I'm looking to see where to send us. Oh, can't send you to AV to the 7th power. She doesn't have her permissions.
Nick's on. Nick Staro's on.
There's a lot of people streaming right now.
Nick's doing Young Thug.
I don't see him. There's so many people here. We've got Broken Baker. We've got Cat Not Williams. There he is. We haven't seen.
All right. Well, I only see Nicholas. I see Nicholas Starro, so I'm going to send my chat over there because I don't see anybody else other than Nick. I don't know why. Sometimes this is it's weird. Sometimes I see who's live and sometimes I don't. So just go tell Santa Claus that we said hello.
Yeah, I'm going to send you over there too. So, how many people do you have watching him right now? Nick Starro, He's currently got a few people watching him. And by a few, I mean 74. He hopefully
give him
he'll have about 900 here in just a second. That'd be fun.
Oh, give him a thrill. That'll be fun.
If all of you go over there, we came very, very close to a blackout. We only three were missing. We didn't get a Yoda side eye. Wait a minute. Let's see. Hey, Yoda. Hey.
Oh no!
Hey,
waking him up.
Yoda.
There it is. There it is.
Sorry for kicking you in the head. You can go back to sleep now.
He's like, what? What the hell?
I'll give you a snack, okay, buddy? I'll give you a snack. You want a snack too, Strobs? Okay.
Dog bark.
Bark dogs.
They just don't bark. And a recitation of the record. We were 2 away. We were 2 away.
You're so cute.
All right. Well, you can sleep on the bed tonight, you two, because you were good. All right, we're gonna head on over there. So, what's coming up is I was supposed to be having an unexplained stream with Flux and Danny on direct at 9 p.m. Eastern on Friday, but I have an emergency work. 2 ships went bump yesterday, and I got to go interview crew members all damn day on Saturday. Yay. So the unexplained stream has been bumped from Friday at 9 p.m. to Saturday at 9 p.m. So join us Saturday at 9 p.m. where we'll be talking to my good friend from Crown Fox Productions, who she is a Bigfoot hunter, a ghost hunter, and possibly a medium. So we'll be talking to her. And then next Monday, probably going to either do the new Lynette videos or catching up on Sarah Boone. We're going to be doing one of those 2 things on Monday. Any last words, Megan?
No, but I'm getting ready to watch Nicholas's reaction. This is going to be fun.
Too.
I've got it all queued up.
Me too. And I've really got to stop talking like this. I'm done now. All right, let's go, people. Tell Nick Starro that Megan and I sent you guys. Take care, everybody. We'll see you when we sees you. Bye.